Hello and welcome to this webinar in our autumn series of webinars. This one dealing with the topic of returning to the office for those of us who haven't yet returned. So what are we going to cover? Well, we are going to have a look at the latest guidance. We're going to focus particularly on the guidance in Scotland and England, although there is also obviously guidance in Wales and Northern Ireland. We're going to address head-on, and I'm glad to say that will be one of my colleagues who I'll introduce in a minute, the issue of COVID-19 vaccination. We'll talk a bit about hybrid working, flexible working, and then we're delighted that one of our health and safety specialists will join us to talk about risk assessments and also how the authorities are enforcing health and safety. So before we launch into a little poll, which is our first activity, I should introduce my co-speakers. The first is Louise Usher, who works in the employment and immigration team here. Louise is one of our employment lawyers. And secondly, Victoria Anderson, who's one of our senior associates in our health and safety team. And Victoria helps clients with health and safety enforcement issues. So she'll give you some great tips at the end about how to prepare for visits from the relevant authorities and what you should be doing to make sure that that visit, if it comes, goes smoothly. So before we get into the topic, we thought it would be great, given that we've actually got quite a high level of attendance at this webinar, to run some polls, because it's quite hard to get data on benchmarking for all of us who are talking about the return to the office. So if we can just put the first poll question up, they're very easy questions. They are anonymous, so please don't worry that we're going to follow up with you. Do you anticipate more than 50% of your workforce, returning to the workplace before the end of this year? I think in the press we've heard lots of different stories about how many people are actually going back, and I think it probably does vary depending on what part of the country you're in, and also perhaps where your ownership sits. With, from our anecdotal experience, American businesses being perhaps keener to get people back than others. So we've got 100% of people who feel like they're going to participate. There's a couple more answers coming in. We'll give you another 5 seconds. Interestingly, it's pretty split. So 46% of the responders said yes, they anticipate more than 50% returning before the end of the year, 54% saying no. So that shows that there's still quite a difference between clients, which is our anecdotal experience as well. Second question, there are only 3 questions. Please don't think we're just going to ask you questions all the time. Second question, have you communicated a plan for a return to the workplace? Yes or no? That one would think it might it might reflect slightly the 46% split on the previous question, but this one, more people have communicated a plan. So we'll just give you another couple of seconds, but with more or less the same level of response, we're at 66% of responders have communicated a plan, 34% have not. So that shows that at least for some of the people, perhaps what we say in this webinar will help inform your plan. Final question, probably the most contentious issue at the moment. Are you proposing to mandate vaccination as a condition of returning to the workplace? Yes or no, or have you not decided yet? And there is, at the moment at least, a very clear winner on this one. We'll give you another couple of seconds to answer, but I don't think the overall stats are going to change much. So 62% of those who responded have said no, 34% are not yet decided, and 5% have said yes. And again, I think that reflects our anecdotal experience. We do have clients who have mandated vaccination as a condition of returning. Most have not, and quite a few are still undecided. So we are going to talk about that. That's going to be Louise's main topic in the session. So turning on to the actual topics, thank you for your participation there. I hope you found that useful for your own organisations as well. In terms of what is the latest guidance, the governments in Scotland and England are more or less aligned, and the alignment is that it's down to us to conduct our own risk assessments. So those legal requirements about distancing and other things, those do not apply in either jurisdiction as a matter of law. But they do apply in terms of requiring you to consider them as part of your risk assessment, and Victoria will talk a little bit more about that later. The key difference at the moment, at least between Scotland and England, is that face masks remain compulsory in Scotland, so there is a legal requirement to wear face masks and to require people to wear face masks in common areas. That does not apply in England. But otherwise, although the words are slightly different, both governments are anticipating that workplaces will begin to fill up more. So we move on to the next slide. We're going to move into Louise's section, which is really this thorny topic of mandatory vaccination. And we're conscious that as we speak, the Scottish Parliament are today debating the issue of vaccination certification as a condition of entry to nightclubs. That debate going to happen about 3 o'clock. And there are lots of governments and organisations around the world who are grappling with this, Canada being one jurisdiction where federal employees and healthcare workers are subject to a mandatory vaccination. So this is a shifting topic, but Louise will do her best to bring us up to date with where we are right now.
Thanks, Tony. So I thought we'd start just by looking at the current landscape on mandatory vaccination in the UK. So at the moment, the government has only legislated for the COVID vaccine to be compulsory for workers in registered care homes in England. It's not, the Scottish government haven't taken the same approach in Scotland yet anyway. But the regulations introducing the requirement on mandatory vaccination are already subject to challenge, and we understand that a judicial review will be launched on human rights grounds very shortly. So we'll obviously be watching with interest as that develops. Elsewhere, the government have said that they intend to consult on whether to extend a requirement for mandatory vaccination to other workers in health and care sectors, as has already been done in France. And again, their position on that remains to be seen in the longer term. But in the UK more generally, the UK government have not indicated that they intend to introduce a mandatory vaccination requirement. Some private sector employers have, however, said that they intend to make vaccination a prerequisite of returning to their offices, such as Google, and I think Facebook and Netflix have also indicated that they may follow suit on that. So in terms of having a vaccination policy, we think that a vaccination or perhaps a return to work policy might be useful for many employers that are thinking about encouraging staff to have the vaccine, even if they're not intending to make it a mandatory requirement. So I think the first thing to say, as has already been identified in the poll, is that mandatory vaccination isn't going to be for everyone. For all employers, there are a lot of alternatives, such as maintaining social distancing, requiring regular testing, and compliance with other government guidance that may suffice for your business. ACAS and CIPD both suggest engaging with staff by running awareness campaigns on vaccination, by offering consistent and accessible data, and ensuring that managers and HR are aware of the policy approach that's being adopted by your organisation. And the general advice appears to be that employers are more likely to get the desired outcome of having a vaccinated workforce as a result of having those open discussions and working to understand exactly why some employees are reluctant to get the vaccine. And as part of that, one of the reasons that we think a vaccine policy might be helpful is that it's an opportunity to debunk some myths about the vaccine that may exist, and employees are then able to make an informed decision about whether or not they want to have the vaccine. If, however, you have already decided or you're thinking about introducing a mandatory vaccination policy, then the first question that you need to ask is why you think that that's something that's necessary. And that's something that's going to be informed by your own risk assessment and also what your employees are doing on a day-to-day basis. You'd also need to think very carefully about what your exemption policy is going to be. So for example, excluding employees with conditions that mean that they can't actually have the vaccine, or potentially excluding those with other protected characteristics, which I'll come on to speak about in a little while. Either way, something else that you may want to consider as part of a vaccination policy is what your position on discussion about vaccination in the workplace is. So we've already heard from clients that Jack doesn't want to work with Jill because Jack's heard that Jill hasn't been vaccinated. You could use a vaccination policy as a means of telling the workforce that you expect vaccination status to be kept confidential, and that a failure to comply with that requirement may result in some form of disciplinary sanction. If we could just move to the next slide. So I've put some background data on this slide about vaccine hesitancy in certain demographics. I could speak for many hours about this, but unfortunately I'm conscious we don't have very much time today. So as Tony said, the slides will be circulated after the webinar, and you'll have plenty of opportunity to look at that in more detail if you're interested. But in terms of a mandatory vaccination policy, we think that the biggest risk is probably of an indirect discrimination claim. So as many of you will know, indirect discrimination arises where you as an employer are implementing a provision, criterion, or practice known as a PCP. In our view, a mandatory vaccination policy is very likely to amount to a PCP. And the question then becomes whether that PCP, when it's applied to your employees, is causing a particular disadvantage to individuals who share a protected characteristic. If an employee is then put to a particular disadvantage because of that PCP, it becomes for the employer to show that the PCP is a proportionate means of achieving a legitimate aim. So in order to have a claim for indirect discrimination, an employee would need to have a protected characteristic. I've set that out in some detail in the slides again, and there's been a lot of discussion about this. To summarise, we think the key risks are really on grounds of disability or on the grounds of religious or philosophical beliefs. So with disability, as I've said, we know that there are some individuals that cannot have the vaccine because of medical conditions, and that's something that would need to form part of an exemption policy. We also know that there may be employees that have disabilities that do not necessarily prevent them from a clinical perspective from having the vaccine, but may make them otherwise reluctant. And as an employer, you'll have an obligation to consider reasonable adjustments in respect of those employees. So that's again something that will need to form part of any exemption policy that you have. With other characteristics such as age, we think the risk is fairly low because the vaccine is now available to all age groups, but we would say that there may be some concern with boosters when we start the process all over again in the future. But at the moment, we think the risk of that's fairly low. With other characteristics such as race or pregnancy and maternity, there may be some risk involved in that, but we do think the key takeaway here is that if someone's concerned about having a vaccination, you need to factor in a route for the employee to be able to discuss that with someone, be it a manager or HR. You'll handle it sensitively, and that gives an opportunity to understand the concern that the employee has and whether it's something that can be addressed with, for example, providing some data or some other evidence about vaccination. Now, the other protected characteristic that I've mentioned that is, we think, one of the most interesting areas is in relation to religious and philosophical beliefs, both of which are protected under the Equality Act 2010. So again, we know that vaccine hesitancy may be higher in some religious groups, and again, that's something that would need to be treated sensitively. And I can't say enough about this process of essentially having the opportunity for employees to address the concerns that they have with someone that is able to kind of address the concerns sensitively. But we also need to think about whether there may be an objection to vaccination as a philosophical belief and whether that's something that's likely to be capable of protection. So in determining whether a philosophical belief is capable of protection, it would be necessary for it to meet the Granger criteria, which I've set out on the slide. So the belief needs to be genuinely held. It has to be a belief, not an opinion or viewpoint based on the present state of the information that's available. It has to be a belief as to a weighty and substantial aspect of human life and behaviour, and it must attain a level of cogency, seriousness, cohesion, and importance. And finally, it must be worthy of respect in a democratic society. So employees, some of which may have strongly held beliefs that vaccines are, for example, harmful to public health, such as anti-vaxxers, in order to satisfy that second Granger criterion, the employee would need to show that there'd been some adherence to a principle so that it's shaped their life or influenced their day-to-day decisions in some way. Simply reading or following journalists or influencers with anti-vaxxing views is unlikely to qualify, in our opinion. If, however, you have someone like an ethical vegan that's objecting to the vaccine on the basis that it's been tested on animals, and they are someone that's had a strong adherence to that principle for some time, then it seems that that might be a view that may be more capable of protection. So the advice in both situations is the same, setting out a process for employees to have those conversations with their employer to try to find a way through once you have a better understanding of exactly what the basis for their objection is. So if they're, the next question is really whether the employee is being put at a particular disadvantage because of the policy that you introduce. And that really depends on what you're proposing. So for example, is it to exclude employees that haven't been vaccinated from the workplace, or is it potentially to dismiss those that haven't been vaccinated? They're both examples that could place those that haven't been vaccinated at a particular disadvantage when compared with those that don't share the protected characteristic. So that being the case, it then becomes the job of the employer to establish that the vaccination policy is a proportionate means of achieving a legitimate aim. Establishing a legitimate aim is likely to be the easier part of the test for employers in this situation, because protecting the health and safety of staff, service users, and third parties is likely to be an uncontroversial aim for employers. Proportionality, though, may be slightly more difficult. Compliance with COVID secure guidelines, introducing regular testing, home working, or redeployment for employees that haven't been vaccinated to roles that can be done at home are options that could be explored, which may be effective and potentially a less discriminatory means of achieving that health and safety legitimate aim. Once again, though, that's something that's going to depend entirely on what your risk assessment is and what it is that your employees are actually doing for work as their job. Finally, I just want to touch very briefly on what might happen if you introduce a mandatory vaccination policy and employees continue to refuse to be vaccinated. We think that if you were to end up in a situation where you were considering dismissal, it would likely be some other substantial reason dismissal. The factors that would then be relevant to that would, of course, be, can the individual be redeployed? Are there other measures that can be taken to avoid the dismissal, such as the measures that I've just outlined, increased social distancing, requiring them to produce evidence that they've been tested? Could those alleviate the issue and essentially mean that the dismissal isn't necessary? And that's a very, very quick whistle stop through the dismissal considerations. But I'm now going to pass back to Tony, who's going to speak about data protection.
Yep. So the ICO is interested, the Information Commissioner's Office is interested in how employers are dealing with vaccination status. And there is now specific guidance from the ICO. Much of it, as you'd expect, this is special category data. This is what those of us who are a bit older call sensitive personal data. So it has to be treated confidentially. You have to only process it, i.e. use it, if you have a good reason for that, and make sure that you've communicated how the data will be dealt with in your organization and who has access to it. Interestingly, and I think our view is that these concept of COVID passes, COVID passports, COVID certification, whichever government you're in, they all call them something different, but something that links to your ID that demonstrates your level of risk or susceptibility to COVID is probably going to become part of our everyday life as airlines use it for travel, as nightclubs might use it to allow us in, if that extends out to large football grounds or rugby grounds or concerts or gigs. Perhaps this will become more ubiquitous in the future. The ICO has said that a visual check of a COVID pass, so in order to get into the building, you hold up your phone, show the COVID pass, and somebody, the receptionist or a security guard, looks at it and says, yes, you can come in. That is not processing, which I sort of understand, but that's not processing. And so you don't need to worry about data protection impact assessments and dealing with the data protection issues if that's all you're doing. You're not storing the record, you're just making a visual check. So I didn't want to say any more about data protection. There is some good guidance on the ICO website. I did want to talk very briefly about whether you should change contracts. My personal view, and it may be different for different businesses who are making more determined decisions, but my personal view is you shouldn't be changing contracts yet. That's principally because I unfortunately think that we're not quite through the crisis response stage. Things may still change. There is talk of October lockdown. There's talk of returning to local lockdowns. There's talk of booster jabs. So changing contractual terms might be too early. You might change them to something that doesn't actually work in whatever the real longer term normal is. So I would say approach your return to work via a return to work policy and some arrangements which are able to change as the situation changes. We know, however, that 92% of workers in a recent poll said they wanted to do some work from home. That will include some people who don't have home working as part of their current employment contract. Some of them may not be happy if you don't permanently change their contract, so they can make a flexible working request if they have more than 26 weeks service. We haven't seen huge numbers of these yet. I don't know if those of you listening have. Most people seem comfortable that organizations are dealing with this through policy and rather than contract change. But if someone does make a request for home working to be part of their arrangements, that is a legitimate flexible working request and the statutory regime would kick in. New starts, so I've said don't change existing contracts, mainly because it could be difficult, but for new starts, perhaps think about whether you want to have more flexibility built into your standard contract. Do you want a bit more discretion about where the employee is required to work to include the possibility of home working within the contract? Do you want them to contribute to the cost of equipment that we're all having to give people who are working from home? And then making sure that you've got the right arrangements for DSE and other health and safety checks. So if hybrid working is the new normal for white collar workers, and people are saying it is, then do we need to update our baseline contract for new starts to make sure that it allows for a form of hybrid working, whatever that ends up being? So some thoughts there. I'm going to pass over now to Victoria, who specialises in health and safety and the regulatory side of it. She'll talk a bit about risk assessments and then also give you some tips for how to prepare for a visit from an enforcement authority.
Thanks, Tony. Yes, so good afternoon, everybody. I am going to kick off looking at risk assessments. Now, I think it's probably very likely that the vast majority of people on this webinar are already familiar with the concept of COVID risk assessments for the workplace. Like all risk assessments in a business, the COVID risk assessment is a living document. And by that, I mean that it's something which will develop and change as time progresses and the requirements and guidance for business change as well. If your business has already produced a COVID risk assessment, but has not yet reviewed it to see if it's still in line with the updated rules and guidance, then we would recommend that you do so now. The most recent changes in Scotland and England, the removal of such strong reliance on social distancing might mean that the risk assessment is slightly outdated. However, fear not, you don't have to start from scratch. But for those who have not tackled this yet, a little bit of background. The purpose of the risk assessment is to provide you an opportunity to look at your office space and think about all the different areas in the office and how all of those spaces are used throughout a typical working day or week. That should allow you to identify how you can then minimize the risks of transmission. And that's the risk that your assessment is looking at here. The things, whether those are physical barriers or policy procedures that you put in place to reduce the transmission risks, are referred to as your control measures. You're using them to control that risk. Now, the Scottish Government has published guidance on returning to the office, which on one of the slides that we will come on to is I've hyperlinked, as well as additional guidance where they have set out what is now the precautionary measures. Now, some of the measures are still mandatory, as Tony's touched upon. Face masks in Scotland remain mandatory, but many measures now are just advisory. The important thing, you don't have to adopt them all, but we do strongly recommend that you consider them all as part of the risk assessment process. So the mandatory ones must feature in your workplace, and in terms of selecting and implementing some or any of the advisory control measures, you want to document that you have considered this. Now, documentation on the slide that's up in front of you just now, you'll see that there's in effect a 5-step process to risk assessment. Documentation is only mandatory under health and safety law if you have 5 or more employees. Therefore, if you do, you must commit your risk assessment to writing. If you don't, then you don't have to. But do bear in mind that in the event of a regulator visit, it's extremely difficult for your business to be able to evidence that they have undertaken that risk assessment process, which is a legal duty. So in short, I think it is always my advice to clients, if you're going to go through a risk assessment process, you should document it, really just as an exercise to protect yourselves. There is also the final step in any risk assessment process is the legal duty to consult with your employees about your business's health and safety arrangements. Now, consultation must be meaningful, i.e. it should provide an opportunity for feedback from your employees. Don't present them with a fait accompli. Give them a draft, take their feedback, consider it. And we also recommend that that process of consultation is also documented, be it by email or a date register, something like that, again, in the event that you are asked to produce evidence of that by a regulator. I'm conscious of time, but I will move on just to quickly look at the guidance. Now, this next slide is where I have highlighted some of the guidance I've already mentioned, some that I'm about to discuss. It's really just there for your reference after today's session. So where are we in terms of what is mandatory? Well, the shift from mandatory to advisory has also slightly changed the preference order, if you like, in terms of control measures. There is a great push at the moment in terms of ventilation in indoor settings. That's, keeping your windows open, using your air conditioning systems, or if your office facility doesn't have that available to it, reducing the numbers of people in the space in the first place. Ventilation guidance has been published by the Health and Safety Executive. There's a link to that on the slide. There's also a link on the slide to the precautionary measures, which is what the Scottish Government are referring to control measures as. So that also highlights things, at least for the time being, avoiding unnecessary work-related travel, staggering your break or eating times to reduce pressure on those key areas at peak times. Moving on very quickly to how you should prepare for and deal with a regulatory inspection. So we know that the COVID spot checks are still being undertaken, and in fact the HSE have been very upfront about their intention to continue these. The first thing that I've highlighted there, in advance, as a business, you want to appoint somebody within the business who will be the point of contact for the regulator. One person who will deal with all questions that come from them. That person, it doesn't really matter who they are, but it should be somebody who is actively involved in your risk assessment process, who has ready access to the relevant documents and who understands what systems your business has in place. There are 2 forms that these spot checks can take. They can be done in person or by phone. Now, because of the sheer volume of workplaces, the HSE might undertake that themselves. It might be your local authority, environmental health officers, or it might be a licensed approved partner who have been approved by the HSE. It's really important that you know who you're dealing with when somebody arrives at your business before you share with them potential information. You can ask HSE and local authority officers for their identification or warrant cards. That will clearly identify them. The approved partners, however, slightly different, but they should be able to produce for you a letter of authorization from the Health and Safety Executive. If you are in any doubt or have any concerns, the Health and Safety Executive have provided a phone number, which I've included on the slide, that you can contact that number to identify or verify the identity of the person who you are dealing with. In relation to what will happen when they arrive, well, yes, they will want to see your risk assessment. They might also want to speak to your staff members. They have the power to do that. They are also really just looking for cooperation from your business. And our advice is that you do cooperate insofar as is possible and as feels reasonable in the circumstances. What we have seen from these inspections to date with other clients who are feeding back to us is that, generally speaking, the regulators are not being overly heavy-handed. They are looking for cooperation. However, in the event that they do have concerns about how you are managing your office's transmission risks, then in the first instance, they should provide you with verbal advice. It might be written, some guidance on how to improve things. As long as the regulator is confident that you are going to take that advice on board and act in accordance with it, then that should be the end of the matter. However, if for whatever reason they consider that the business might not cooperate, then they can take more formal enforcement action. Now, there are two types of enforcement notice: improvement notice and prohibition notice. An improvement notice, as the title suggests, requires you to improve upon a process that's being undertaken in a workplace. Prohibition notice stops you from doing something. It's really important to note that that can be a single process, or it can be the operation of the whole workspace if the regulator considers that that is necessary in the circumstances. Finally, just to highlight, it is a criminal offence to fail to comply with either type of these notices. The notices can be subject to appeal in certain circumstances, and as is always the case, we strongly recommend that you seek legal advice promptly if you find yourself in the unlikely situation that you receive one of these notices. I'm conscious that we are now over time, so I will just cut it short there, other than to highlight that in terms of solutions for our clients, Brodie's does offer the Workbox subscription for employment law and also a free downloadable health and safety by Brodie's app, which both products are linked on the slides. And I'll hand back to Tony.
Thank you very much. We've had a couple of questions. I'll only take ones that are short. One for you, Victoria. If someone is split working in the office and at home, should you carry out a DSE workplace assessment for both?
In the office, your office working should already be subject to DSE assessment on an ongoing basis. That's probably something that you will have had from before the pandemic. And in terms of home workers, the HSE guidance is that once we hit the longer term, that's the phrase that they use, longer term home workers. So if it does become a contractual change, then yes, you are required to carry out a DSE assessment, or rather to provide a digital DSE assessment to the employee to complete at home for their workstation and feedback to the employer. There are very good health and safety executive links for that information, which we can add into the slides to send out.
Yep, or just go on the HSE website. I think that stuff is really good. Most clients are using that. Another question about face coverings, someone saying they're not mandatory in office environments in Scotland as long as a 1 metre minimum distance can be maintained. I think, yeah, we weren't saying they were required to be worn the whole time. It's only in what I think are described as common areas or areas of high congregation. So that's the legal requirement. But when you're sitting at a desk, so long as you're socially distant and your risk assessment allows it, they're not mandatory. Conscious we're at 12:35. There are a couple of other questions. We'll get back to those who've provided names, but we're very keen to try to keep these webinars bite-sized. So thank you very much for your attendance today. We are going to push a very short survey out to you straight after this webinar. If you are able to respond to it, that would be absolutely fantastic. We really value the feedback to help us shape future webinars. But otherwise, if you have any need for help from Victoria's team or our own team, please get in touch, and good luck with your return to the office.